Welcome. If you're getting ready for the Queensland Bar exam, you already know that procedure isn't just about filling out forms. It's often where a case is really won or lost. So today, we're going to master two critical tools in your procedural toolkit, Sections 25 and 33 of the Civil Proceedings Act. These are the rules that govern the strategic transfer of cases between courts.
Think about this, because you will face this exact scenario. Your client's claim is properly filed in the Supreme Court, but the other side wants to get it bumped down to the district court, probably to save a bit on costs. This is way more than just a procedural skirmish. It's a genuine strategic battleground, and knowing your arguments here is absolutely essential.
So here's how we're going to break it down. We'll look at the transfer power itself, then the key discretion test you need to know from the Tickner case. After that, a jurisdictional trap you have to avoid, then the rules on costs, and we'll wrap it all up with a practical checklist for your bar exam.
Okay, let's get right into it and start with the engine room, Section 25 of the Civil Proceedings Act. This is the section that gives the Supreme Court the fundamental power to manage its own workload by shifting cases up or down the court ladder.
Now, the key thing to get your head around is that this power works both ways. Under subsection 1, the Supreme Court can pull a case up. Maybe it involves a tricky new point of law, or it's just unusually complicated. And then, under subsection 2, it can push a case down, usually for efficiency. But, and this is the big catch, the lower court must already have jurisdiction to hear it.
Right. So just because a case can be moved doesn't mean it will be. And this is where we get into judicial discretion. The modern authority you absolutely have to know for this is the landmark case of Tickner.
This quote right here is the perfect starting point for any argument you make. Justice Crowe in the Tickner case confirmed that the court's power is incredibly wide. It's unfettered, broad, and unconstrained. But that doesn't mean it's arbitrary. Not at all. That power has to be used in the interests of justice, and it's based on the real-world, practical facts of your specific case.
So what does interests of justice actually mean? Well, this is your practical toolkit from Tickner. You've got to ask yourself, how complex is this case really? How serious is the injury? Is there a real shot the damages award could blow way past what was first pleaded? And what about the practical stuff, like court backlogs? Could my client actually get a trial date sooner in the Supreme Court? And remember the big takeaway. The dollar amount is just one factor. It is never the final word on its own.
All right, now for a crucial warning. Knowing the rules is one thing, but knowing the traps, well, that's what makes you a great advocate. The case of Bartolo is a perfect example of a classic mistake that you absolutely have to avoid, both in the exam and out there in practice.
This right here is the golden rule, the non-negotiable gateway for any downward transfer under Section 25, subsection 2. The lower court must, at the very moment the application is being heard, already have the power to hear the case. You just can't ask the court to transfer it based on something that might happen down the track.
So let's break down the flawed logic from the Bartolo case. The defendant tried this really clever but ultimately doomed maneuver. They argued, hey, the parties could theoretically consent to give the district court jurisdiction later, so Your Honor should just transfer the case now. The court gave that a flat no. You can't use a hypothetical future event as a kind of springboard to create the jurisdiction you need today. It just doesn't work.
And Bartolo also gives us a neat little reminder to always use the right tool for the job. If your problem is about the level of the court, Supreme versus district, you're using Section 25. But if the problem is purely geographical, like you want to move a case from Brisbane up to Rockhampton, then you're using Rule 39 of the UCPR. Don't get those two mixed up.
Okay, so the transfer order's been made, the file is on the move. What happens to all the legal costs that have already been run up? It's a critical, practical question, and thankfully, Section 33 of the Act gives us a nice, clear default rule.
This rule is all about fairness and giving your client some predictability. Section 33 makes sure that parties aren't unfairly punished by transfer. All the work you did while the case was in that higher court gets assessed on that court's higher cost scale. It prevents any nasty surprises later on.
Here's exactly how it works in practice. Let's say your case gets transferred from the Supreme Court down to the district court. By default, all the work done before that transfer is recoverable on the higher Supreme Court scale. Then, every single thing you do after the transfer date falls under the district court scale. It's simple, it's clear, and it's logical.
Okay, so we've covered the power, the discretion, the traps, and the costs. Let's boil this all down into a super practical checklist that you can use to structure your arguments when you're sitting that bar exam.
Here it is, your 5-point plan. First, always argue the Tickner factors. Second, you have to confirm jurisdiction so you don't fall into that Bartolo trap. Third, use the correct rule for court versus venue. Fourth, do your cost housekeeping with Section 33. And finally, number 5, always do a quick check for any specific legislation that might override these general rules. If you can nail these points, it shows you have total command of the topic.
So, why does all this matter? Because mastering these rules isn't just an academic exercise. It's how you control the story of a case, how you manage costs for your client, and how you gain a real strategic edge. This is what changes you from someone who just knows the law into an advocate who can actually wield it. So go through the cases, get this checklist in your head, and you'll be ready. Good luck.